Hi everyone, thanks for joining us for our presentation on wills and estate planning today. We're with Spencer Chu, Associate at Concilium Law Corporation, and he'll be going through the slide presentation. We've muted your videos and your mics so that for your privacy, and also so that we can cut out any background noise. We will be recording the session, so you'll be able to refer to it in the future. And if you do have any questions, you can click on the chat icon at the bottom of your screen and type them in, and I'll be keeping track and then putting them to Spencer at the end of the presentation. So, Spencer?
Okay, thanks, Catherine. And thank you for joining us wherever you may be from. As Catherine mentioned, this is a short introduction on wills and estate planning, and it will be about half an hour for us to get through this. Just briefly, this is the topics that I'll be talking about today. First, we'll talk about the differences between passing away without a will, meaning to say that you pass away intestate, or if you have a will, what happens then? Namely that your estate can be divided and distributed according to what has been spelled out in your will. We'll also talk about what can and cannot be included in a will, and touch on the appointment of a testamentary guardian, meaning to say you appoint a custodian to look after your children, and you can do that by way of including it in your will. So first up on intestacy, for purposes of this presentation, I will only be talking about persons who pass away, non-Muslim persons who pass away. The reason for that is because Muslim estates are governed under Sharia law, and they are distributed in accordance with that. So in Singapore, when a non-Muslim passes away, his assets will be distributed according to the rules of intestacy under the Intestate Succession Act. And what this means is that where a party has movable property, that property will be regulated by the law in which he was domiciled at the time of his death. And I'll explain a little bit more about this in a bit. Whereas for the distribution of immovable property, things like houses and condominiums, that is regulated by the Intestate Succession Act itself. So to give you a bit of an example, when do we apply for either a grant of letters of administration in Singapore? You do that when a person dies intestate and he or she is domiciled in Singapore, meaning to say Singapore is his or her permanent house, permanent residence, country of residence, and if he possesses movable and or immovable property in Singapore. Otherwise, you can still apply to Singapore if the person was domiciled outside of Singapore but possess immovable property here in Singapore. If the person has if the person only has movable property, you can still apply here. But if the person also has immovable property situated outside of Singapore, then you will have to apply to a court in that particular jurisdiction in respect of those immovable property. And in Singapore, the order of intestate succession, it goes like this. It's fairly straightforward. If you only have a spouse, the entirety of your estate goes to that spouse. If you have spouse and children, they each get half. If, for example, if one of the children had passed away and they had children themselves, meaning to say you are a grandparent, then your grandchild can actually claim their parents' share. If you only have children and do not have any spouse or parents, the children will receive the entire estate. If you have a spouse and parents, your parents and the spouse would split half of the entire estate. So it goes down in order of succession. Next, coming to if you only have parents, you're unmarried, for example, then your parents get your entire estate. Otherwise, your siblings would then have a claim to the estate, followed by grandparents and uncles and aunts. If you do not have any of these first 8 relations, then the government will retain the entirety of the estate. So just to touch a little bit more about intestate succession, it's basically you do not have a choice as to whom obtains what share of your estate. If you want to make a specific gift, for example, if you have a family heirloom that you want to pass down, that also cannot be done if you pass away intestate. And that brings us fairly nicely to the topic of wills. And basically, a will is an instrument, a written instrument, where you, as a testator, you can express an intention as to how your property ought to be distributed after your death. You can make specific gifts to persons, not necessarily just family members. You can also do things like I mentioned earlier on, appointing a guardian to look after your children. You can also set up your wishes in terms of your burial or cremation and whatnot. A will only come into force upon your demise and does not come into force any earlier before that. If, for example, you have that family heirloom that you want to pass on, you can actually do so before you pass away and you don't have to include it into your will if that's the case. So what makes a valid will? First of all, it has to be in writing. You as a testator must be above the age of 21 and of course of sound mind. You should also sign at the end of the will after setting out how your assets and your estate is going to be distributed. And at the time when you sign it, it should be witnessed by two attesting witnesses. They will also sign at the bottom of the will. Just bear in mind that these two witnesses cannot be beneficiaries of the will or spouses of the beneficiaries. Otherwise, those gifts itself will be deemed invalid. Things you can include in your will include immovable property. So, for example, if you have a condominium, a HDB flat, a condominium or a private house, if they're in sole names or if they're listed as tenancies in common, you can include that in your will. If it's listed as a joint tenant, as most HDB flats in Singapore are, then that cannot be included in your will. All other joint properties held as joint tenancies can also not be included because they will be distributed according with the rights of survivorship. Other things that can be include movable properties such as investments in your own name, bank accounts, insurance policies, subject to whether there have been nominations. Art, as I mentioned, family heirlooms, jewelry, personal artifacts, that sort of thing. If you do have liabilities, you should also set out how the debts should be paid off before the rest of the will is distributed. And as I mentioned earlier, again, you can appoint a guardian for your children. A will cannot include what I mentioned earlier on, any asset that is listed or held in joint names, because these assets would be distributed in accordance with the right of survivorship. So all properties held as joint tenants, if you have bank accounts or joint investments, they will also be granted to the surviving joint account holder. In Singapore, things like CPF monies or pensions, equivalent to our pensions, they are distributed by way of nomination. So you simply log on to the CPF website and request and appoint your nominee there. Same goes for insurance policies. Most insurance policies would include the beneficiaries, and they will also include who you have appointed as your nominee. So just check with your agent to see whether whoever you have appointed is in fact the person that you intend to be the beneficiary of the policy. Okay, and lastly, coming to the appointment of guardians, in Singapore there are generally two types of guardians. The parents themselves, they would obviously be the natural guardians. However, any of the parents can also appoint what is known as a testamentary guardian. This is done either by way of including and appointing a guardian in a will or by drawing up a trustee. If you are going to be drafting or attesting to a will, you can just include that in that one document. It kind of saves you some trouble there. And what this testamentary guardian does is he or she actually acts as the joint custodian of the child together with the surviving parent. If there are no surviving parents, then that testamentary guardian acts as the sole custodian. So who can be a guardian? That guardian that's appointed must be 21 years of age and above. Again, he must be of sound mind. He does not need to be biologically related to the children, meaning to say, as a lot of our expat clients face sometimes, you can be a close friend that's appointed. And you can also appoint more than one guardian at any time to be appointed to look after your children jointly. That sometimes acts as a type of check and balance. In some instances where the surviving parent is not deemed to be appropriate to be a guardian, the court can appoint one also. Okay, so that shows that the court in Singapore does have a fairly wide discretion to make and appoint guardians as long as they are in the best interest of the children. So for some of our expat clients, these are some of the issues that they face sometimes when appointing testamentary guardians. For example, a lot of their family members or the persons they want to appoint as testamentary guardians actually do not reside in Singapore. So what happens in such circumstances is, in theory, the child is orphaned or left alone in Singapore with nobody to look after him or her. When that happens, the Singapore authorities actually have a duty to look after the child until the appointed testamentary guardian arrives in Singapore. The Singapore authorities will then take the child into social care until the testamentary guardian arrives and takes over custody of the child. So to skirt this potential issue, what some of our clients actually do is they put in place an appointment of a temporary guardian who resides in Singapore, such that if anything were to happen to them, the temporary guardian can take over custody of the child and look after the child until the permanently appointed guardian travels to Singapore to take over custody. And I think that concludes the very brief overview of what happens in intestacy, when a person has a will. Basically, in terms of court procedure, there are certain differences when you want to obtain a grant in order to distribute the estate as an executor if there's a will, or as an administrator if there's no will. In short, there are a number of additional steps that you will have to take if there is no will. They include the possibility of having to put in an administration bond, which is a sort of bond provided to the Singapore courts to ensure that you will administer the assets and the distribution of the estate fairly. I think Catherine has prepared or Catherine has received a number of questions before this presentation, and I think it may be a bit helpful to provide some insight into some of the more practical considerations and issues faced by individuals. Catherine?
Hi, yeah. So I do have prepared questions. I'll address the questions that have come in first.
Sure.
And then go through the other questions that I'd already prepared. So someone had just mentioned step siblings, and I assume this is, with regard to if you die intestate and the passing on of the properties, etc. So is there anything that you would like to mention about step siblings?
Okay. Step siblings, if they have been legally adopted, then they would be entitled to a share of it, of the estate as well. If they are legally adopted, they would fall under your children, basically. And depending on whether there is your spouse has survived you or whether only the children remain, they will be split according to that particular order.
Okay. Up to what age can children be under a guardian?
21.
And the cost of making a will in Singapore, roughly?
The range is fairly wide. I know, for example, there are some free will making services out there. There are some that pitch their wills at a fairly low rate. I think essentially what you need to consider is first have a look at all your assets, put it in a sort of pool, and see how you want it distributed. If it's fairly straightforward in that you wish to give the entirety of your assets to your spouse, for example, then there is no issue generally in adopting or using one of the either free or fairly cheap options. Usually you would want to spend a bit more and be a bit more detailed if, for example, you want to make specific gifts to specific people. And if you have complex considerations that you want to include, say, for example, if you want to incorporate, if you want to build in a trust for your children and how the monies in that trust are going to be used, you want to take that into consideration. Or if you want to stipulate other conditions such as that hypothetically your child will, or rather, one that I've seen is that where, let's say, a faraway descendant has a number of years to come forth, and if he or she comes forth, then he or she will be entitled to a share of the estate. But it all depends on the testator and what he or she wants. Other considerations may be, it may be useful to seek proper advice rather than using a template if you have assets strewn across the world. Because sometimes wills may overlap and detailed reading needs to be done in order to ensure that there are no loopholes or there isn't a will that revokes all other wills, that sort of thing.
Okay, thank you. Would you suggest to have a nomination done on insurance policy or via a will?
The nomination via the policy will take precedence. So you should always ensure that that is the case and always keep that updated.
Okay. And just to clarify that if there's no nominee done for the insurance policy, then it will be dispersed as in slide 6, which you'll be able to refer to because we're recording this slide presentation in the order on that slide there, right?
So meaning to say if there is no nomination in the policy, then you can include it in your will. However, we would also suggest that even if you do have a policy with a nominee, a nominated beneficiary, you should still include it in your will, just to mirror identically what or who has been appointed as your beneficiary. The reason for that actually is to make the job of your executor a little bit easier. At least he or she will be able to refer to that one will and ascertain what all your assets are, rather than having to potentially write to various insurance companies or to ascertain whether you have a policy with them.
Okay, thank you. What is movable property versus immovable property?
Okay, so as I mentioned earlier on, immovable property generally refers to like your houses, your condominiums. The actual definition of it is that it's either land or a benefit that arises but it's attached to the earth. So basically, it's a permanent fixture. And movable property is basically anything that isn't immovable property. So what you have is movable property is something that is attached to the earth. Condominiums, HDB flats, private housing. And movable property can include things like your car, your bank accounts, investments, insurance policies, jewelry, and the like.
Thank you. Someone just wanted to clarify, so without a will, and I think this refers again to slide 6, isn't everything to the child or children by default?
So it depends on the person's circumstances. Let me just go back to that slide. Okay. So, yes. So the order of intestate succession is really you look at scenario 1 first, and if that scenario doesn't apply, then you go on to scenario 2, which is spouse and children. If that doesn't apply, then it's number 3, so on and so forth. So if that individual circumstances are such that he or she only has children, then obviously 1 and 2 will not apply as there's no spouse that's surviving.
Okay, thank you. What constitutes being domiciled? I know there's things like divorce. Sometimes people claim domicile in a country they're not actually living in at the time. I assume that's not the case for this, but can you clarify, please?
Okay. Well, a domicile is generally the country that a person treats as his or her permanent home. Either that or that person lives there and has a substantial connection with that country. So it doesn't necessarily mean that just because you reside in Singapore means you're domiciled here. If you are here only on assignment for work and it's a short term, then while you might be habitually resident in Singapore, you're not necessarily domiciled here. So the intention of that testator actually plays a part.
Okay. If I'm not married but been living with my partner then as a couple, and I die, my partner won't receive anything then if I don't have a will. Is that correct?
Yes, that's correct. So again, referring to this order of intestate succession, you'll see there is no contingent for a live-in partner, or even if it's a live-in spouse, a common law spouse, because Singapore doesn't recognize that. So unfortunately, in those instances, it would be ideal to draft a will. Otherwise, the surviving partner would not have any claim to the estate.
Would a surviving parent automatically become the primary carer for the children, even if I had the other party who passed away had appointed a testamentary guardian? And what if I don't agree with that?
Okay. So on this slide, what I mentioned was there are 2 types of guardians, a natural guardian and a testamentary guardian. A natural guardian is the surviving parent. So a surviving parent does automatically become the primary carer of the children. If the deceased parent had not appointed or didn't appoint any guardian, then you will be the sole custodian of the children. If the deceased testator did appoint a testamentary guardian by way of the will, then what happens is that testamentary guardian will act jointly with the surviving parent as the joint custodian of the children. And you mentioned that what happens if you don't agree with that? So if a mother, basically if a surviving parent objects, he or she can actually apply to court to have that appointed testamentary guardian removed, and it is at the court's discretion to decide whether the guardian ought to remain. or to be removed.
Right. If my partner dies first and then I die and I didn't agree to who he had put down in his will as guardians, what happens? Because already...
So basically,
if I passed away,
that's basically like as you mentioned, if you object to the appointment of the guardian, as long as there's a testamentary guardian, that guardian must act jointly with the surviving parent. That's the starting point. If the surviving parent has objected, then they should apply to court. If, for example, it should be based on the fact that the guardian is maybe unfit to have joint custody of the children, or if they feel like the guardian is not making decisions in the best interest of the children. You apply to court, and the court can either refuse to make an order for the guardian. So in that case, the surviving parent becomes the sole guardian. The court can also order that both the surviving parent and the testamentary guardian jointly act in the best interest of the children. Or they can decide that the guardian ought to remain, but maybe in a limited capacity.
Okay, thanks. I think we've got time for just 2 more questions. Can other family members contest who I had named as a guardian in my will after my death?
No, only the surviving parent or the surviving spouse can object to the appointment of a testamentary guardian. All other family members will not be able to do so.
Okay, thanks. And lastly, in terms of financial support, so if I'm divorced, my ex-spouse died, but he'd been paying the maintenance, school fees, etc. for my child, and not left any money in trust for my children after his death. What would I do about that?
Sorry. The question was, you are really divorced?
Receiving maintenance from my ex-partner, and he passed away, and there was nothing in trust for my children for paying the school fees, etc. How can I make any claim on?
Okay, so if you're talking about maintenance for yourself as a spouse, that would cease upon his death. So you will stop receiving, or your entitlement to receive spousal maintenance will cease. If you're talking about children's maintenance, then you actually can apply on your child's behalf for child maintenance, and you do it under the Inheritance Family Provision Act in Singapore. There, the court will make an order for reasonable provision of maintenance. It may not be to the sum that they were receiving throughout post-marriage, but it's based on what the court deems fit, and it's made out of the net estate. So however, you cannot make an application where the estate is affected such that it takes up too much of the estate. If that is the case, then the court will step in and either give a lower sum of periodic maintenance, or they may make another sort of order. So that you need to ascertain what the total of the estate is as well before you make such an application.
Right.
15 hours. As I mentioned, maintenance is generally given periodically on a month-to-month basis until the child turns 21 years old. Unless the child has a disability, then it continues on unless that disability ceases. If one of the children is a daughter and the daughter gets married before the age of 21, then the maintenance will also cease to her. And lastly, if let's say the estate is a fairly small one, if it's less than I believe if it's less than $50,000, then the court also has the discretion to provide a lump sum rather than a periodic payment of maintenance.
Okay, thank you. I just have one more question I think we can squeeze in regarding domiciliation again. What if one is PR in Singapore but residing, say at the time, for example, in Thailand?
So again, because it depends on the testator's intention. Where do they treat, which country, Singapore or Thailand, do they treat as their permanent place of residence? Or is Thailand merely a place that they are staying for a short time with the intention to move back to Singapore, in which case Singapore may be the domicile. So ultimately it depends on the testator's intention.
Okay, thank you very much, Spencer. So I think we'll leave it there for today, running out of time. But if you do have any further questions, please don't hesitate to contact Spencer. All the contacts email addresses are on our website and our Facebook page. And like I said, we'll be posting the recording of this slide presentation also on the website and the Facebook page for your future referral. Thanks everyone for joining us today.